A preliminary objection regarding maintainability of the second appeal has been raised by learned counsel for respondent on the ground that no substantial question of law is involved in the present second appeal stop. The said question therefore, is also being adjudicated upon stop para. The plaintiff appellant had filed a suit for declaration with regard to the suit premises which was decreed by means of the judgment and decree dated 31st March, 2003, but the first appeal was allowed by means of the judgment and decree dated 16th February, 2015, leading to the filing of the present second appeal. Stop para. Learned counsel for appellant has submitted that the suit premises had earlier belonged to Srimati Abida Bano, who was the owner in possession of the house bearing municipal number 337/1991, having purchased the same by means of a registered sale deed from one Altaf Zain staff. It is submitted that the plaintiff appellant entered into the suit premises as a tenant of Srimati Amida Bano, who was widow but issue-less staff. Learned counsel submits that due to the care being taken by the plaintiff appellant, Srimati Abida Bano, being pleased with his services, gifted the suit premises to the plaintiff appellant by means of an oral gift deed, that is, a hiba staff. It is submitted that merely to recognize the oral gift deed, a written deed of hiba nama was also executed on 10th April, 1972, while delivering formal possession of the suit premises on the same date staff. It is submitted that subsequently the defendant respondent filed SCC suit number 715 of 1980, claiming herself to be the owner of the entire suit premises, due to which the plaintiff appellant was compelled to file the present suit number 32 of 1982, seeking the relief of declaration staff. It is submitted that since the plaintiff appellant was already in possession over the suit premises, no further relief of possession was sought nor was required to be taken in the plaint. Stop para. Learned counsel submits that the trial court framed four issues, with the first issue pertaining to the ownership and possession of the plaintiff, and issue number 3 being framed with regard to the ownership of the suit premises by the defendant staff. He has submitted that after examination of evidence, the suit has been decreed in favor of the plaintiff appellant by means of the judgment and decree dated 31st March, 2003, which was appealed against by the defendant respondent staff para. Learned counsel for appellant has further indicated that the first appellate court had framed 3 points of determination, with the first point adverting to the question regarding validity of the oral hiba and the ownership of the plaintiff on that basis staff. The second issue framed by the first appellate court was with regard to the suit being barred in terms of the proviso to section 34 of the Specific Relief Act, 1963, staff para. Learned counsel for the plaintiff appellant has submitted that the first appellate court has erred substantially in law in reversing the judgment and decree of the trial court, primarily on the ground that the reversal has been done with regard to findings of fact recorded by trial court without scrutinizing the set findings and pointing out any errors there in staff.